before I can. But I have a connection, and it's so good to see you again, and at a distance to revisit Baton Rouge, which I remember with great fondness. I have certainly take into account those Baton Rouge lectures that you mentioned as a kind of background to what we're talking about today, though our focus is on emancipation and George Washington and Abraham Lincoln. And some people may wonder why I pulled those two together in that manner. But there's a specific reason for that. Of course, when I talk about the Emancipation Proclamation, what I'm describing in my essay on that topic is what I call prudent statesmanship. Lincoln's careful and patient deliberations about the question of emancipation. He was under enormous pressure not unlike the pressures we see today when public opinion polls, hammering politicians are demanding action on something which isn't forthcoming from the executive branch. And that's the kind of pressure Lincoln was receiving from early 1862 and even before, up until the time in September he announced that he would be proclaiming emancipation after the beginning of 1863. However, Lincoln had made his commitment to that already by July the 7th in 1862. He hadn't announced it. He was already prepared a couple of weeks later to pronounce it, but then was persuaded by his cabinet and his generals that it would be unpropitious to announce an Emancipation Proclamation at a time when the Union had suffered some reverses in the war. It would seem a measure of desperation. Out of, therefore, concern not to give it the cast of desperation, he delayed announcing it, which meant putting an immediate response. And that led Lincoln in August of 1862 to respond to a letter from Greeley, which is so frequently quoted today. It's quoted by people, for example, in the 1619 Project, other people who are hesitant to embrace Lincoln as an emancipator. And in that letter, what Lincoln said was, if I could end this war by freeing all the slaves, I would do it. If I could end this war by freeing none of the slaves, I would do it, and so forth. In other words, he gave a measured response which committed himself to nothing, while nevertheless making clear that he would do whatever he could to save the Union. So that he was putting off the frank announcement of emancipation because the time was not right, not because he was hesitant or because he had any ambivalence about the question of emancipation in the revolted territories at that moment. So we see an act of statesmanship, careful thought, deliberation. And that act is paralleled. It's paralleled, for example, in George Washington, when in 1794 through 96, he was going through the crisis of the Jay Treaty, which produced just as much public outcry once John Jay came back with the treaty. It was resisted in the popular press, and he had to have Alexander Hamilton wage a campaign in support of his decision to ratify the Jay Treaty. But at the back of the Jay Treaty, something that has gone largely unnoticed in the scholarship was the decision not to include in the treaty a provision to either return the slaves carried away by the British or to compensate the slaveholders for them. Now, that decision was not merely a decision to give in to British pressure, or even mainly that. It was primarily a decision, as was frankly explained by Alexander Hamilton in an essay, that was contrary to natural law and to moral law. So for moral and religious purposes, they did not include compensation for or the return of the slaves. That slight blow against slavery signaled what was Washington's mature understanding of the nature and problem that slavery was in the United States. And that's the same understanding that's reflected in his final farewell address. I say final farewell because Washington gave several farewells. He gave the farewell in June of 1783 at the close of the war, the farewell in which he projected the future of the United States when he said, we have a national character to establish. What was that character to be? It was to be the character of a free, self-governing people committed to principles of improvement, amelioration in human progress. In other words, what Washington himself called progressive principles at that day and age. Those progressive principles, of course, included what's reflected in his position on the Jay Treaty, or what was reflected in his final farewell, which wasn't the 1796 farewell address, but his last will and testament. In Washington's last will and testament, of course, we all know he liberated his slaves, including slaves whom he had never held directly, i.e. slaves who were legally entailed to him, but had never, in fact, been in his possession. He arrived at that decision carefully, and he prepared for it even more carefully. Well, we must recall that he spent 8 years during the Revolutionary War not directly tending to his own property, which fell therefore into some degree of distress. He only had a few years back at Mount Vernon before he was called to New York, then Philadelphia, to build the new government. Again, not being able to give as much attention to his own property as he would have wished to do. When he left the presidency in 1796, therefore, he had only 3 years left. He died in December of 1799 to try to put his property back into decent order. And what the last will signifies is that he had finally reached the point where he could not just liberate slaves, but provide for them in such a way that he was not casting them on blind fate. Washington understood that this declare slaves free was meaningless unless slaves had somewhere to go and someone who would receive them. And that was, of course, not to be assumed in the United States of 1799. So that he had to prepare to liberate his slaves, and he had to provide for the slaves, and he did so. And still more meaningfully, one provision of his will was that which said it wouldn't be well, that meant he wanted still to get the value of the slaves for his wife instead of just freeing them. But they misunderstood. The law of the widow's third in the colony, now state of Virginia, would have meant that no matter what was contained in Washington's will, a third of the property belonged to the widow. And so he couldn't actually effectively free all the slaves until he cleared the hurdle of the widow's third, which he cleared by that provision that they would be freed upon her death, which meant they couldn't descend to someone else who would gain by title, by way of the title of the widow's third. So what we see in Washington and in Lincoln is a deliberate, thoughtful process about a fundamental moral predicament which they regarded as necessary to be resolved for the sake of the fate of the country. In Washington's case, what that means is this. His last will and testament is not just a private document. It's a public document. That's why I call it his last farewell. We see it not only the testimony about the slaves, but the testimony about education and the provision for education. He had, ever since his first inaugural address, said to the country, we must be concerned about education. We should build a national university. In his 1796 farewell from the presidency, he repeated that. In his last will and testament, he comes back to the theme. So throughout, he's emphasizing the development of the character of a people who would be educated and habituated to embrace the principles of self-government, to embrace principles of freedom. And that meant including embracing fundamental moral principles that are consistent with slavery. So what we have between Washington and Lincoln and the question of emancipation is recognition that it is not enough just to recognize the humanity of the slaves. One must also cultivate towards the slave a ready embrace of their freedom. And that is what took place between the first administration and the 16th administration of the presidency in the United States with respect to the question of emancipation.
Well, thank you very much. That's your beginning statement, I take it, and that I can't tell whether you froze on Zoom or you finished, but I think you finished. So for your starter, so let me pose a question about that, and I'll start. Well, let me start this way. You speak of Washington's very careful deliberation, right, with regard to slavery and how to bring the principle of freedom, which he embraced in his maturity, into practice with regard to his own estate. But if I could take you a step back, Washington was also at the Constitutional Convention of 1787, of course. And there were several, to some people, maybe to all of us in a way, notorious, well known in that sense, and maybe sinister, certainly many think so, compromises with the institution of slavery. I wonder what you can say about slavery in the Constitution, and if Washington played any role in relation to those compromises.
Well, I certainly can address that question. It's important, but I want to put it first in the context of a letter Washington wrote in 1786. He wrote this to Morris in Philadelphia on behalf of a Virginia slaveholder named Dalby. Mr. Dalby had traveled to Philadelphia, and some activists in Philadelphia had sought to liberate the slaves that Dalby had brought with him. And Dalby was protesting to the Philadelphia government against this irregular and illegal practice, and asked for.
And Bill, could you clarify for us what was the legal stake? Because Pennsylvania had abolished slavery by then, right? But they had provisions for visiting congressmen or something of that sort. Is that right? Or visitors generally?
There was free travel, and of course the Constitution that was looming was going to ratify the practice of moving freely between the states and among the states with one's property, which means that the law in Philadelphia or in Pennsylvania against slavery didn't free a slave from Virginia simply because that slave happened to be in in Philadelphia. So that Dalby thought that he had been badly treated and wanted some rectification. So Washington wrote to Morris explaining what Dalby's request was. And then he did two very important things in the letter. He said, look, I'm not making an argument for Mr. Dalby or for slavery. However this case turns out, I leave it to the law to determine. But what I do want to underscore is that the question of slavery is a question to be resolved by legislative provision, not by arbitrary interposition or fiat. It will be no good to the country to abolish slavery outside of systematic legal procedures, what we've come to call the rule of law. So that he just underscored that. And then he went on to point out that he had no deeper wish than the wish to see slavery abolished. But he understood that that could only be effective, as I said a moment ago, if it's accomplished through legislative processes. So that letter sets the tone for what we see in 1787 and what are called the compromises. The Constitutional Convention was not ready to abolish slavery. It had minor discussions of it, but we all know that with the exception of James Madison using it to break up the small state, large state conflict, it was avoided largely throughout the convention. A few mentions here or there, but every time it was mentioned, it produced embarrassment, such as that when Gouverneur Morris, who had once declared property is the end of government, the protection of property, had to change his mind when the question of slavery came up. So we know it was an embarrassment for them. They were not therefore compromising on the principle, they were avoiding the conflict. And those two things are so vitally important to distinguish. And even when we speak of the compromises, only one can be called a compromise, and guess what? We read it exactly inversely to what it was as a compromise. And that is the 3/5 compromise. Highly educated and intelligent people to this day still cite that as indicating the view of the founders that Africans were only 3/5 human beings, which was absolutely false. Why false? Because the original provision arose in 1783, not in anything having to do with representation or the right to vote, but having to do with taxation. They had in the Confederation Congress sought to come up with a way to raise revenues. They couldn't assess property because their first impulse was a property tax. Couldn't assess property. The rude conditions didn't permit it. So they said, let's use a proxy, population. But once you introduce population, you introduce a problem. An enormous disproportion between the North and the South in terms of free population. There were so many slaves in the South and relatively few non-slaves, which meant that the South would be undertaxed in relation to the North. And so they said, well, we must count the slaves also, because they're human beings, they're people, and they represent by proxy the value of property the same way the others do. And naturally, at that point, those in the South wanted to minimize the weight of slaves in the scale. They would have preferred 0%, while in the North, they would have preferred 100%. They settled on 3/5, which meant the North largely carried the day, counting as far towards 100% as they could get agreement on. That was the compromise about taxation in 1783. Now here's the second part. The language in that provision, when it enumerated who the people were that were to be counted, referred to counting all free white persons and other free persons. And it excluded Indians not taxed. And it said, when it said all free white persons, men, women, and children. And then other free persons. So what does that mean? That means women were not excluded in the original 3/5 provision. They were included. Secondly, who were the other free persons? Remember, Indians are excluded as not taxed. The only other free persons in the United States at that time were free Black people. They were being counted 100% under that provision, the 3/5 clause. And that did not change when the clause was adopted in 1787 into the Constitution. It was only edited in a minor way to improve the language, the expression, but its substance was not changed. So that those who interpret that as somehow representing a depreciation of the value of Africans are exactly misrepresenting it in the opposite of what in fact was accomplished. So that sets the tone for the other compromises. One, return of property, return of persons, not slaves, duly bound to service in one of the states from any of the other states, which leads, of course, ultimately to the Fugitive Slave Act of 1850, among other things, and also informs the Missouri Compromise in the 1820s. So that is not so much a compromise. That is simply saying that, yes, if we're going to have these relationships of comity among the states must enter into an agreement that they will respect one another's claims to property as long as those claims exist. But how long will such claims exist? Well, that's what the final compromise in the Constitution addresses. We are going to abolish the international slave trade. Well, some specific people, Rutledge in particular from South Carolina, says, oh no, we cannot sign a constitution that will do that. They debate it. What does it come down to? It says, well, we won't do it right away. We won't do it until 20 years. But after 20 years, we will abolish the international slave trade, which meant that the defense of the Southern position only accomplished minimally the goal that was sought. That in fact, the anti-slavery position prevailed in that compromise. So in all three compromises we see, the Constitution is exactly what Frederick Douglass said it was in 1854, an anti-slavery document.
Thank you. Now here's a second question about something else that you said. You spoke of the first presidential administration and the 16th and the progress. You spoke of Washington's mention of progress and of the progress from one to the next. But in your article on the Emancipation Proclamation, you bring up the Treaty of Ghent at the end of the War of 1812, which in contrast to the Jay Treaty actually discussed that issue, right, of enslaved people who had run away to the British and gotten their freedom, and those who'd been taken from the masters and who sought compensation for them. Could you tell us a little more about that? And didn't that indicate something of that reversion or a step backwards from the progress that Washington envisioned?
It did indicate reversion at the superficial level. Remember that the first several presidents were all Virginians. Washington was only one of that series of Virginian presidents who had that firm moral commitment. It is true that James Madison opposed slavery and was a slaveholder, but he never acted, apart from joining the American Colonization Society, to do anything about the problem of slavery. He deferred to his constituents far more strongly than Washington did, so that when it came to the claims of slaveholders, he was prepared to defend them, even if he didn't think in principle they were defensible. Now, he had a Secretary of State who was an abolitionist, John Quincy Adams, and who was responsible for negotiating the Treaty of Kent. So that unlike Jay, who had his instructions from Washington, Adams had his instructions from James Madison. He was not able to complete the Treaty of Ghent without including the slavery provision. But a very interesting thing happened in the aftermath. There was a debate about what the slavery provision actually meant. And so they had to submit it to arbitration. And they chose the Russian Tsar as arbiter. Now, guess where John Quincy Adams began his political career? In Russia. He was sent to the American mission in Russia. He became ambassador rank there. In other words, there were connections. He chose people he knew, in effect, to arbitrate the meaning of that provision. And as the arbitration was completed, it undermined the strength of the provision for compensation in return. So it was only nominally accomplished. So what I'm suggesting, and there is no documentary evidence to prove this, but I think circumstantially, contextually, I'm suggesting that John Quincy Adams had to include it, but did everything he humanly could to avoid fully enforcing it.
Interesting. Here's another question that's occurred to me in relation to prudent statesmanship, as you say, and Washington and Lincoln. Washington, I guess this is not quite the same, but Washington was faced, right, and had correspondence with Henry Lawrence, as I remember, over the question of slavery. And then Lincoln has a public correspondence. I guess that was a private correspondence. Lincoln has this public correspondence with one of his generals, Fremont.
Yes.
Out in Missouri, and he actually countermands Fremont's early Emancipation Proclamation in Missouri, right? Am I remembering that right? How does that fit into the whole prudential calculation and the statesman-like calculation of these different men?
I think it fits in perfectly well. I think it goes right back to the 1786 letter concerning the affairs of Mr. Dalby. What Lincoln was concerned about, both in Missouri and in South Carolina, where this happened also, was he was concerned about generals acting by fiat and getting out ahead of the development of law. Remember, he had Francis Lieber working with him to develop a code of war, legal practices. And Lieber, who was a man who was a German emigre, but had begun his career in Columbia, South Carolina at the university there, before ultimately moving to Columbia in New York. And Lieber, who actually had a slave, only a domestic slave, nothing else, when he was in South Carolina, nevertheless became the Union man. So this philosopher, you might say one of the first pure philosophers in the United States, had become a pure Union man, and he was the one who drafted the rules of law, the code of law, a code of war for the United States. And that meant to create both a clear chain of command and adherence to certain moral and legal principles in the course of the conduct of war. So that Lincoln was in the position of enforcing his authority, in addition to preventing renegade generals, shall we say, and certainly you can apply that term to Fremont, enforcing his position against their attempts in an almost Napoleonic manner to insert authority outside of the requirements of legal process. So it's the same principle that was enunciated in the Dalby letter. Those changes must come about in due order, following fully recognized and authoritative constitutional practices, and not by way of fiat.
And so the exception then where moral action can sort of skirt the law is Quincy Adams
Yes.
and his deal with the czar, because
Yes.
there it wasn't an explicit violation of the law. It was just a kind of prudential deed on your account, which you
Yes.
admit is a speculative account. But in the clash between morals and law that Lincoln and Washington both saw, they felt that there was somehow a higher moral calling to the law for the sake of morality down the road.
Yes.
Even though at the time it meant sustaining, at least for the time being,
Well, in fact,
an immoral institution, an institution that they both saw as immoral.
yes, as a matter of fact, I could make it even more emphatic because, as we know, Lincoln, throughout his entire effort to fend off the surging power of slavery, was mainly concerned with one thing: restoring the commitment to equality. Now, he understood that consent of the governed was absolutely essential. This is, I think, the core principle that Harry Joffman has taught through all his work, that it was the consent that was necessary to preserve freedom and to preserve, therefore, self-governing people. Hence, we could not alter the relationships that had existed in the southern states until we found a way to acquire their consent to it. Now, that seemed like an impossible task. Remember, a house divided against itself cannot stand. And yet it was the task Lincoln set for himself. We must act in such a way that we can continue to appeal to the authority of consent, the consenting members of the community, long before we can accomplish the full moral fruition of what those principles promised. And we saw this, of course, in 1807, when the slave trade was finally outlawed, and there ensued a debate about what to do with contraband. And that's one of the more interesting chapters in our national history, as far as I'm concerned, because we saw the North and the South, again, at loggerheads, but the North made a plausible argument. They said, wait a minute, you start out by saying, if you find this contraband, you'll set them free in the North. But why should we have to welcome them? Why should
This would mean, to clarify, this would mean if someone tried to run slaves into the Union despite the law now against it after January 1, 1808, the ship would be seized, but then the question is what is done with the Africans on the ship, right? Yeah.
Right, and just remember what typically happens in the case of smuggling. We'll forget the human beings for a moment.
Right.
People smuggling goods. When you apprehend the smugglers, the government gains title to the goods.
Right, and then you sell the goods for the, right, okay.
And you sell the goods. So that's a conundrum. We can't stop the smugglers, take the slaves and sell them in the interest of the public. That defeats the purpose. So now what do? Well, we set them free. Well, where will we set them free? Well, the South said, you're not going to set them free to run around among our enslaved population, giving us a bad example. And the North said, well, you're not going to set them free here. We didn't bring them in. We're not responsible for this. So there's a huge conundrum, what to do. And again, what they ended up doing was simply silently leaving the slaves to be dealt with wherever they may be found, according to whatever prevails in the community in which they're found, which meant, of course, that some would end up slaves, even though they were imported against the law. But that avoided the government taking property in the slaves, title to the slaves. Now that whole question, that whole problem, in a way, underscores the problem of consent, right? Who are the members of the community? Not every human being is a member of a free consenting community. People have a right to decide how they want to act collectively and with whom. Therefore, they, by definition, exclude some. Well, who is to be excluded? Anyone they choose. That is the bottom line. And it is unavoidable, morally or philosophically. Thus, one can say slavery is immoral, it's against religious law, it's against natural law. But one cannot conclude from that that people who are threatened with slavery are therefore necessarily entitled to rights of citizenship in the community that abolishes slavery. That takes an additional step. And that's what we have struggled with ever since, therefore, the whole question of the 14th Amendment.
And so that will lead to what's going to be the last question I ask you, and that has to do with how you interpret Lincoln's only preliminary, because of his assassination, plan for Reconstruction. How did he think that consent could be given? This actually is a local question in Louisiana in some respects, as I understand, because I think his most thorough plan had to do with how to deal with bringing Louisiana back into the Union. What do you make of his plan, and do you think it had any chance of succeeding had he been able to serve out his second term?
I believe the heart of Lincoln's plan lay in the 15th Amendment. And that is why he devoted such energy to that. The 14th Amendment was important for recognizing the legal status and even the citizenship of the freed slaves. But the 15th Amendment did something far more important. What it said was they will also participate in the practices of citizenship, the most important of which is voting. If you can integrate, and this is used in that 1860s sense, the freed slaves in the political determinations of the respective communities, you can more surely bring them back into the Union on a foundation that acknowledges the full thrust of the fundamental principles of the Declaration of Independence. That was at the center of Lincoln's Reconstruction plan, to get the mutual and reciprocal participation of ex-slaves and ex-masters in common political decision-making.
It's true, and he emphasized, right, that, and help me if I don't remember this correctly, that the vote, he encouraged the Louisianians to give the vote to those who had fought for the Union, at least, and maybe others with a property qualification or education or somehow had proven themselves. So not universal suffrage yet, but some sort of compromise.
Yes, it was the beginning, the first step on the road. And that's what he was doing. But he was trying to get to foster among them a willingness to act collectively across racial lines. That's the bottom line. That's what we have to underscore.
Well, I think that should, between us, open up plenty of room for questions from the audience. On Zoom, as most of you know, there is a function for raising one's Zoom hand. It's probably on a button that says reactions, and there are all sorts of icons there, and I don't need the icons, but there should be a little button that says raise hand. So if any of you have a question, if you could raise your hand, click the raise hand button, I'll recognize you, and if you have trouble with that, turn on your camera and start waving, or send me something in the chat, and we'll see if we can go with questions. So the first question, I think, was from Ken Masugi, or were you just clapping, Ken?
Well, sorry, I didn't know whether, I didn't want to raise the hand that just had the middle finger on it.
No, that's the thumbs up, actually.
Oh, okay, all right.
There's no obscenity in the in my version,
all
at
right,
least.
Good. Okay, my eyes are bad here. Well, thank you. I wonder whether Lincoln would have said you needed the 14th and 15th Amendments. Since, for example, suffrage in the states was universal manhood suffrage. I think even in the southern states, with the possible exception of South Carolina. So once, and then constitutionally, of course, once you have this new definition of persons for functional purposes, they're no longer, if they're no longer slaves, then what do you need a 3/5 clause for? So so I guess my first question would be, um, would Lincoln really need the 14th Amendment, given the view of citizenship on the state level at the time? And related, I think related to that would be my second question, is the 13th Amendment abolished slavery, but as Lincoln said, neither a slave nor a master be. Uh, uh, does it also abolish mastership, right?
Yes, they're very good. Let me start with the first question. I believe it is fair to say that it was the 14th Amendment that made the 3/5 clause moot. That after the 14th Amendment, there would no longer be a calculation of representation in the House of Representatives based on that distinction. And that's the only role that played in those deliberations. And that's the reason that the 14th Amendment would have certainly been necessary in terms of removing even the appearance of a distinction in qualifications for counting towards representation. With regard to the 13th and 15th Amendment, I think there are two different questions. The purpose of the 13th Amendment is to accomplish what couldn't be accomplished by the Emancipation Proclamation. For there were, of course, non-revolting states in which slavery was not abolished by the proclamation. The 13th Amendment was the act, therefore, that made the abolition of slavery universal. And so that exhausted what that potential was with regard to that. The 15th, an entirely differing story, it seems to me. As we were saying a moment ago, it's the amendment that prefigures actual mutuality, reciprocal interaction between the ex-slaves and the ex-masters. Now, it is possible to take your teasing formulation, Ken, that mastery could survive, which we know from all of the various forms of pseudo-serfdom that continued for some time after slavery, called sharecropping and other things. But that mastery is not a legal title. And the only mastery that's important in this particular drama is the legal title of master, i.e. the title that conveys a property interest. Without the property interest, mastery depends entirely upon character. And no one can sustain that claim without sustaining the claim of character. And interestingly enough, that claim can be sustained by individuals who were themselves ineligible to be called masters legally theretofore. So that it seems to me what's really critical is to see that the 15th Amendment opens the opportunity for anyone to become a master.
Thank you. We have a question from Professor Aaron Sheehan Dean of the History Department, who's written a bit on the Civil War. Aaron?
Hey, Jim, thanks, Professor Allen. I enjoyed your talk. I wanted to follow up your comments about Washington. It seemed to me you were talking about him approvingly, in an approving manner, that he was deferring to the kind of legislative process to resolve the problem of slavery. And so I wonder how two things fit into that formulation. The first is the Somerset decision, which empowers abolitionists coming while there's still a British Empire before the Revolution, but a very important, even though it doesn't end slavery in the empire, it's nonetheless an important part of the process of changing the law of slavery. And then, of course, slaveholders, persistent efforts culminating in Dred Scott to use the courts as a mechanism to advance and defend slavery. So I guess I'm challenging you in the sense that it seems to me that people at the time, although they wanted legislative kind of dominance and they wanted statute to protect slavery, were also more than willing to use the courts and other sort of legal vehicles to try to either end or protect slavery.
I thank you. That question is really very, very important. And I certainly agree with the foundational premises. We know, for example, that in the case of Prince Hall and many others in Massachusetts, that the Somerset decision did in fact inform their attempts legally to confront the question of slavery. So that from the beginning, the appeal to the courts has been integral to the resistance to slave society. And that continued What's more interesting about your observation, however, is how that appeal to the courts turned in the after the first third of the 19th century towards the defense of slavery. And we saw, and one of the things I described in my essay is how Justice Taney gave a foreshadowing of Dred Scott already in Prigg versus Pennsylvania, a decision, the outcome of which he agreed with, but from which he nevertheless dissented, because the principle underlying it would have reinforced federal authority. And he wanted to make clear that there was no interference with state authority with regard to the question of slavery, which he ultimately therefore gets to in the Dred Scott opinion. So yes, the courts have been there always in those roles from the beginning, and it has been a contest between the contradicting sides. But what Washington is talking about is slightly different. And I didn't use the word deference deliberately when referring to his dependence upon legislative authority, because he really means the process by which laws are established with clarity for the community, bounded in consent. And so that consent is expressed through the legislatures. And that's what he's talking about when he speaks of legislative process. And we should understand that when he was writing the letter about Dolby, he was privately corresponding with the Virginia Assembly. He was supporting and hoping to achieve a legislative resolution in Virginia on the question of slavery. This has been insufficiently discussed in the historical literature, but Washington had a great deal dependent upon that, because he saw that as a wedge for the entire country. If Virginia could be gotten through its House of Delegates to end slavery, Washington conceived that would change the entire nation, very much in the spirit in which James Madison, in his party press essays, describes Virginia as an aristocracy for one reason only, because of the number of slaves in the population, because he determines the difference between democracy and aristocracy on the basis of the weight of population participating in ruling the society. And given the number of slaves, the weight of population ruled against democracy and toward aristocracy. And that was the kind of principle Washington was trying to get established when urging abolition in Virginia. And he expressed the deepest disappointment that that was not successful. But at the time he wrote the Dolby letter, it was still pending. He was still hopeful for it.
Thank you. Aaron, did you want to follow up or happy? Okay, good. Thomas Cloud, I think I saw a question from you.
Hi, Dr. Allen. Actually, I have two questions. One's a quick historical one on Washington, which is, I believe I read in one of your pieces that Washington was initially confused why some of his own slaves might have run away. And that's just a historical question. I don't know if that's true. Might be bad memory on my part. The other question is the circle of consent, where you draw that circle. Could you bring that out a little bit more in terms of, popular sovereignty versus maybe legitimate? What would be different? Like, is that Douglas's position? That's the hard circle, right? So.
Right, I think that's very good. And let me take the first question first. Washington was disappointed, he was even angry. And he didn't have many slaves run away, but he did have some slaves run away. But he was angered by that when they did, because he could not see any reason why they would do so. He actually considered himself to be a fair and just master, because he didn't see himself primarily as a master. He did see himself as a manager, as an entrepreneur. He was as hard on his overseers, they weren't even called overseers, his foremen, his property managers, as he was on slaves. There's no difference in the way he treated the one and the other. And so he thought no one had a reason to run away by reason of the treatment they received. And for that reason, it angered him. But that happened in very few cases. And indeed, the only prominent case of a runaway, which illustrates completely Washington's attitude toward it, is the runaway slave Oni Judge. Now, Oni was actually Martha's slave. Oni was a young girl, a late adolescent, who was with Martha, had always been with Martha as domestic servant. in Philadelphia, and she ran away. And Martha had the sense that she had been seduced by a suave French speaker, if not French person, who took her away from Philadelphia to parts unknown. And Martha resented that, not so much from the point of view of resenting Oni Judge, but as much from the point of view of thinking, this is like a daughter to me, and what's going to happen to her in this world following some creature like this? She's likely to be abused and worse. So she, that Washington, find Oni and bring her back. And that was the most energetic pursuit Washington ever undertook for a runaway slave. But he didn't undertake it by posting billets with her presumed features described and returned dead or alive or any of that such nonsense. He largely wrote to friends. He got word that she might be in Connecticut, and he wrote to Trumbull and others in Connecticut and said, look, if you can find Oni, please ask her to come back. But, and he's very explicit about this, she's not to be compelled. Encourage her to return, but she should return of her own will. Oni never returned, but that is how Washington resolved that. So I think Washington in relation to the runaways is a very different picture than is often painted by those who are determined to convey all of American history under the dark cloud of racism. It had nothing to do with that. Now, the second question, of course, that you raised is the question of how do we measure consent? In other words, do we actually require participation in elections to talk about consent? Well, that's not the Declaration of Independence perspective. The Declaration of Independence perspective is consent is an original act of the community, which must be followed by a secondary act. The secondary act is what organizes the community. That's how the legislature springs into existence. Now, the forms of legislation and the participation and appointment of representatives and executives and all the rest, those have a vast range of possibilities. They can vary in multiple ways. And that includes vary with respect to the franchise. Who gets to exercise it? Is it only males? Is it universal? Is it only property holders of a certain denomination? All those things can be determined in the original constitutional or consenting formulation of the community. But the original consenting formulation doesn't entail any specific arrangements following that. Those must be individually determined within the respective community, informed by what they regard as necessary procedures to defend the existence of the community, first of all, and to assure it's operating in a manner in which people can repose confidence. So we don't confuse suffrage with consent. Now that's something that's very hard for us to do in the 20th and 21st century, where we think consent is in fact ephemeral. But if consent were ephemeral, there would not be ever any constitutional authority in the community. That is why we require not mere majorities to create a constitution, but extraordinary majorities. Not mere majorities to change it, but extraordinary majorities. Because the founding consent is meant to perdure, to last through time, and to structure a community that can nurture what those expectations were without reverting to the day-by-day changes in opinion and sentiment in the community. That was, in fact, the very tension at the heart of the origin of political parties in the United States. To what extent should the sentiments of the people on any given day determine the conduct of the government? That was what divided Republicans, the Jeffersonian Party, and the Federalists, the Hamiltonian Party. And as Washington indicated in his farewell address, Washington embraced the notion that the will of the people is expressed through the elected representatives. It is not expressed ephemerally, day by day, by the people themselves. They express it only by choosing representatives. And so that formality is more than just a formalism in the Republican theory that was embraced by people like George Washington.
So you mean when people speak about voter suppression today, you're saying that that's a name given from the Jeffersonian tradition,
Yes.
but it's not universal in the constitutional tradition. If those denied the right to vote are denied on the basis of a principle in law that's established for the point of securing whatever constitutional ends the polity is seeking. Is that right?
That is not only right, but it is emphatically so. If the constitutional procedures are followed, then voting is not suppressed save for constitutional purposes. It is not suppressed for partisan purposes. So this idea that it is the will of the people, an almost Robespierrean sense of will, I suppose, that can be therefore manifested or represented in some kind of dictatorial expression, that has nothing to do with the consent of the governed under the Declaration of Independence or the Constitution. The emergence of that idea gained its common currency for our time through the presentations of Woodrow Wilson, unhappily enough, who saw himself as somehow speaking the will of the people. Yes, when they elected him, he represented them, but he did not therefore channel on a day-by-day basis. He was elected to exercise judgment in which the people reposed confidence, not to reflect something that was supposed to be a mythical sense of the people or mythical sentiment of the community on any given day. So that is a huge dividing line in American partisanship, and we continue to struggle with it to this day.
Thank you. There's a question in the chat, which I'm going to go ahead and ask, although I think the person who asked it may have had to leave. Considering the divisions in the United States today, how do we preserve and unite the Union with the consent of the governed in the manner of Lincoln? In other words, how can prudential statesmanship of Washington and Lincoln help us with our present predicament?
Well, I wish I had a simple answer to that question, but I do not. I will say this. It is certainly the case that what Lincoln did do was remind us that we don't actually unite on anything other than fundamental principles. And so when he described the people who had come to the shores of the United States long after the founding and who therefore had no participation in the heritage of the founding directly, but he could nevertheless describe them as bone of the bone, flesh of the flesh, he meant in terms of their embrace of the principle, primarily the principle of equality. If we cannot unite on the principles in clear and simple terms, we cannot unite at all. If we're confused about the meaning of equality and think it means equity, for example, then we have no hope of becoming united. The fact that the terms have some sibilance, some similarity of sound, doesn't mean they mean the same thing. And indeed, those near relations can often be used to undermine the prospect of community. So we have someone like John C. Calhoun, who appeals to the notion of consent, of course, but in such a way as to divide. And we see similar things being done by people today who will presume to be appealing to consent when they're actually denying the prospects of consent across the community as a whole, or at least an extraordinary majority of the community, and who want to be able to act instead on the basis of simple majority rule, and to therefore claim for the simple majority the authoritative weight of the community as a whole. Because that authoritative weight of the community as a whole can only be conveyed through constitutional arrangements, can't be conveyed outside of constitutional arrangements.
So maybe you answered the question I would ask to follow up on behalf of our shy fellow. And that is, but aren't we always divided into parties, right? So that we interpret equality differently, we interpret liberty differently. And part of that would be just built into the nature even of a healthy democratic politics, right? When does it become unhealthy? I take it has something to do with this division you suggest between constitutional authority and the supermajoritarianism behind that. But I wonder if you could spell that out a little more.
Yes.
When are partisan divides, when do they become a constitutional problem, and when are they the ordinary life of a vibrant republic?
Well, you asked precisely the right question, it seems to me, and I think the answer is fairly straightforward. The partisan differences which nature entails and which we discover everywhere we find human beings become fatal when they require changes of regime. So when you cannot pursue the course of your own partisan commitment without changing the regime, it becomes destructive. And no matter what promise you identify in it, you will not in fact achieve it, because the cycle of regimes is unrelenting. That is to say, if you require a change of regime in order to advantage your partisan perspective, you necessarily leave counter perspectives to require a change of regime to advance themselves. And if that happens, then you are right back in the age-old cycle of regimes. And so all you can do is take turns exploiting one another.
So is that what we have in America today, that we've got this, pretends to be the vibration of parties, as Hamilton says, within the Constitution, but in fact, we're looking at really radically different regimes alternating back and forth politically?
I'm tempted to quote Christ speaking to Pilate and say, you're the one who said it.
Let me go back to the floor for questions. We have someone who has asked one already, who has his hand up, and that's legal, but I'll give anyone else a chance if who hasn't participated before going back. Do we have anyone else who hasn't spoken, who has a question he or she's been saving? If not, let's go back to Ken Masugi.
Hi, and I'm going to go back to the 13th Amendment, which of course modifies the whole Constitution, that is including parts that have no direct reference to slavery. And in particular, Article 4, which contains privileges and immunities clause, citizens of the different states, which you could use for well, the abolitionists tried, but they were rejected on that. But with now, with the abolition of slavery, I think the privileges and immunities clause comes into play, and also the definition of Republican government. That too changes from the constraints that slavery put on that form of regime. So, but you still insist on the 14th Amendment, which I don't reject the 14th Amendment. I just think you could have all of its advantages through the original Constitution.
I don't deny that that's true in significant respects. I think I understand the 13th, 14th, and 15th Amendments in the context of the aftermath of war and what we would call the unsettled questions. Now, by unsettled, I do not mean to say that you could not have found their answers in the Constitution. I mean to say you couldn't find the answers in the community, that people were unsettled. We'd spent a long time debating the Privileges and Immunities Clause. The Corfield case and others left that in something of a quagmire, frankly. And therefore, that people would turn to try to find a crisp statement of what was meant by that seems to me quite natural enough. Natural impulses are not always prudent impulses, but nevertheless, they're still natural. And it seemed to me that it was very important in the aftermath of the war to try to find some kind of consensus statement about what it was that constituted citizenship in the United States and what would be the expectations of that. Now, what we know is that in the immediate aftermath, while these amendments are being passed, they're also being passed a series of legislative acts, the Civil Rights Acts. There are a couple of them in that immediate period, leading to Reconstruction. And the very fact that those were contentious and contested indicated that the unsettled questions were not fully resolved by the 13th, 14th, and 15th Amendments. And it's a fact, probably correct to say, we haven't quite resolved them to this day, because we have tried to foist a series of legal interpretations on what are relatively straightforward principles that have made them more the subject of wrangling than any agents of clarification.
And Ken, when you're talking about the 14th Amendment, is your objection to Section 1, or are you speaking about the other sections as well? Because to make a point that was only partially made before, right, the irony of the end of the Civil War and the abolition of slavery is that the South now gets more representation in the federal government, right? And that's what leads to, almost directly, leads to the clauses, Section 2 of the 14th Amendment, the one that was never really put into effect, and then the 15th Amendment as the alternative to that, to ensure that voting by the freedmen is used to make sure that this representation does not mean that the ex-slave power, I mean, so the power of the ex-slavers, of the masters, becomes greater in Washington than it was even before the war.
Sure. Well, that's the irony of the abolition of slavery, is that you do get this increase in Southern power that has to be tamed somehow. I think, well, when Andrew Johnson became president, I mean, I think Lincoln's strategy just was destroyed.
Yeah.
So
I agree with that.
Grant had a good chance of, I think Grant wanted to do what Lincoln intended, but something never worked.
We have, maybe will be our last question, because I think I promised you release, although we started a little late, although you shouldn't be punished for the technical problems. But we have a question from Professor James Viator of Loyola Law School here in New Orleans. Jim, the floor is yours.
Dr. Allen, nice to see you again. Haven't seen you since my days as a teaching assistant at Harvey Mudd College.
Yes, good to see you.
Back when we both had a full head of hair.
Yes.
Good to see you again. I have a question, I guess, for the House, because I'm very interested in this. I'm very interested in your use of Washington's will. It's an incredibly complicated and interesting document. And my question today is, does anybody know what Martha Washington did in her will? Because George Washington tied his will tightly to hers.
Yes.
And I think there's unease in his will about what he is doing. Now that's a bit subjective on my part, but I see two things happening in the will. One is he gives to Martha what the Code Napoleon would call a usufruct over all of his disposable property, including the slaves he owns completely. He says, I bequeath the use, profit, and benefit of my whole estate, real and personal, for the term of her natural life to Martha. So she will have the profit and use and fruits of all of his slave property for her life. Mm-hmm. And then in the next paragraph, he says, I feel really, he doesn't say I feel bad, but he says, I earnestly wish I could free slaves now. Mm-hmm. But due to the intermarriage and the intermixture of my slaves with the dour slaves, this would produce hardships and sadness. And so I manumit them upon my wife's death. And of course, that means she gets to use all of their profits and fruits all of that time. But all of that hardship of breaking up, free families and slave families, he's delayed until Martha's death. And it kind of depends on what she does in her will. And of course, if she frees all of the slaves, then there's no hardship and sadness in the families in the quarters. But if she bequeaths her slaves to her descendants, then that hardship and sadness will happen at her death. So I guess my question is, it seems like George Washington is aware of the family necessities and the bonds of affection in the quarters, and he's worried about causing discord, but he also knows that he's only delaying that discord, that it's going to happen when Martha dies. If she does not free her slaves and she bequeaths them to her descendants. And also he's looking after Martha and saying, all of these slaves, even mine that I could free now, you're going to have the profits of all of their slave labor. So I find this will to be a very complicated document and worthy of a dissertation, probably, to read the two wills in context. But it shows his love for his family. It shows his concern about slave families. But in a sense, to use the modern phrase, he sort of kicks the can down the road to what is going to happen in the future with the dour slaves as well as his slaves.
Well, Jim, I think it is certainly appropriate to worry about those implications as you have laid them out, I think quite correctly. But I want to say there are two ways that this must be looked at. And the one is, of course, that which you've elaborated and which I'll respond to last. The first is the one I think never gets sufficient attention. And that is the extraordinary bond between George and Martha.
Mm-hmm. Oh, yeah.
One must recognize that he did not act unknowingly. He knew Martha. She knew him. And their commitment, their mutual commitment, was exceedingly strong. It was not an accident that she arrived at the determination as early as 1796 that Thomas Jefferson would never be welcome in her home again. She was completely identified with George, that she spent all those winters in the terrible conditions with the army during the war, going to be with them. He could not come home. He didn't get home only 2 nights in 8 years during the whole course of the war. There was an extraordinary bond, one itself worthy of much closer study than it has received to this point. So that he wrote the will with that knowledge. That must be added to everything else in interpreting the will. Now, to get to the will itself, yes, he conveyed usufruct to Martha, but that specifically means he did not convey property or title, so that she could not transmit it. She could only through her natural life benefit from it. Once that were done, his determination prevailed. So that what you must see is that what he has done is structure the will so that even in the worst condition, he will still accomplish at least a significant measure of his purpose. And that's what he had 2 wills. He told her to burn the one that had been written earlier, and the last one, which he'd written essentially by himself without legal consultation, and which firmly stressed what he wished to accomplish. That made clear what the results would be at minimum. Now, at maximum, many things are possible. It is the case, of course, that Martha, upon her death, did comply with all his wishes and even freed some of her own slaves. How many of them in the households? No one has bothered to calculate that. Mm-hmm. But we know something very important. We know that Mount Vernon was essentially in disarray scarcely 40 years later after his death, i.e., he did not leave Martha, or Martha did not leave that estate in a condition to continue the enslavement of those who were enslaved there on that property. And so that would lead properly to the inference that, in fact, she largely not only complied with his wishes, but participated in them to a significant extent.
I put in the chat something I found on the Mount Vernon website the other day, 10 facts about slavery and George Washington. And the last one has to do with Martha's apparently manumitting
Yes.
a number of the slaves even before, although they also mentioned that Abigail Adams figured she did it out of self-interest because she was afraid that she might be done in by those who wanted to hasten her death or something of that sort.
Well, I would discredit that, but I would say
Yeah.
I participated with the people at Mount Vernon building this exhibit, Lives Bound Together, several years ago, and it's still present there in the museum. And I recommend it to anyone who wants to get a deeper understanding of that relationship between the Washingtons and their slave property, to go visit and work through that exhibit, because it tells the tale quite well.
Dr. Allen, thank you so much. And of course, Washington and Martha's lives and his life as the first president and founding father in chief are intertwined in this will, and there's so many cross currents. Love and devotion to family and to take care of family after you're gone, and yet the desire for emancipation. And something modern students don't like to hear is that honorable men have to make good decisions, not perfect decisions.
Yes, very good. Yeah, thank you.
Well, in that case, I think we've now, Bill, even with the glitches, used up as much time as we agreed to, and I know other folks have things to do. But thank you very much for joining us today, for your conversation, for consenting to let us put it up on the website, and I hope that we get a chance, at least in person at some point, to welcome you back to Baton Rouge, or in any event to get together somewhere and continue these conversations. So thanks to all of you for coming, for your questions, and especially thanks to William Allen for his thoughtful and uniquely penetrating discussion.
Thank you very much, Jim. We'll see you again, I'm sure.
Very good. Bye-bye.